Hello, everyone, and welcome to today's Cathedra webinar, live on September 12th, 2025. If it's your first time attending one of our webinars, Cathedra means learning in Creek, and today you will be learning about NAHASDA's admissions and occupancy by the amazing Cheryl Cosley. My name is Brianna Birch, and I am the Training and Development Coordinator here at the Native Learning Center. We're so happy that you all could join us today. Please follow along as I begin to read the disclaimer aloud. This webinar provides a summary of fundamental concepts, requirements, and/or procedures within the allotted 90 minutes. The material discussed does not illustrate all possible scenarios that could be applicable. Also displayed here is our copyright infringement law. This is just a friendly reminder that the webinar presentation materials are protected by copyright, trademark, trade secret, and other intellectual property laws. Before we do get started, I want to familiarize you with the learning platform and where things can be found. I've put a link to today's PDF slides in the chat. You can also access a copy of the slides as well as access today's webinar recording in the future by going to the courses section here on our platform. Any resource items for download are also available within the online course as well when you go through the course pages. And each time you're ready to join one of our webinars going forward, you're just going to log into the website and click on the large green banner that's going to be across your screen, like depicted in the picture there. And when you first join the webinar, it's going to prompt you to complete an audio test before joining. Please select the listen only option so that we can avoid any audio feedback during the webinar. And if you need to change the speaker that your sound is playing from, you can select the phone icon down at the bottom of your screen. And this is going to bring up a list of your speaker and mic devices so that you can choose your preferred audio method. So let's get started. We are so happy that you're here, and we are going to rely primarily on the public chat if we want to talk or say anything. So in the left-hand gray menu panel, you can open the public chat and the shared notes as well. If you click on the public chat, you're going to see a chat open between all webinar attendees, as well as the NLC facilitator and your webinar instructor, Cheryl. Just click in the box that says send message to public chat, type the message that you want to send and hit enter, or click on the blue paper airplane icon to send your message in. Please also send your comments and any questions that you may have in the chat, and feel free to use the raise hand feature in the bottom right corner of the screen if you think we missed something, or if you want to say anything or ask any questions. Any tech support issues can also be submitted there, and I'll try to support you and help you navigate through it. If you also click on the shared notes section, you're going to find some helpful links I've placed there, like a link for today's webinar survey, the feedback survey. We do highly encourage you to complete it just to let us know how we're doing. You'll also see a link to the location of our Cathedra webinars archive on the YouTube channel, a link to connect with us on LinkedIn, and a link to bookmark for easy login to Cathedra Constant Learning in the future. And at this time, we really love to get to know who you are. And of course, we'd be honored if you let us know your name, where you're joining us from, your tribal affiliation if you do have one. You may also be a tribal employee, and your work or role in Indian country that may have led you to today's webinar. But while we're doing that, just a final note and final reminder that try not to click on the green menu panel that's going to be all the way to the left of your screen, because if you do click that panel, it's going to take you out of the live webinar. But that's fine. If you do end up accidentally clicking this, you can just rejoin again by clicking the green banner up top. And with that, it's my great pleasure to announce or introduce today's webinar instructor, Cheryl. Cheryl, I'll hand it off to you now.
Thank you. Thank you very much, Brianna.
Welcome.
Okay, guys, welcome. You made it to the last day. Day 5, admissions and occupancy. Good job. So welcome and good afternoon. I just got done smudging. Again, this presentation is brought to you courtesy of the Native Learning Center and the Office of Native American Programs. My information is at the beginning and the end. All of you know me by now, but we don't know who and when anybody looks at the webinar. So we do the introduction regardless. My name is Cheryl Cosley. My Anishinaabe name is Redbird Woman, and I'm Loon Clan. I come from Place of the Pike, Keno-Shinkoning in my language. It's Bay Mills Indian community. Our reservation is located in the Upper Peninsula of Michigan, at the very top. Our waters actually border Canada, and I am Ojibwe or Chippewa. I served as director of housing for my tribe for over 28 years. During that time, I was the chairperson for the Great Lakes Indian Housing Association. That's 31 tribes surrounding the Great Lakes region under the Chicago EWONAP office. I also served for 16 years on the National American Indian Housing Council, NIHC. I started as the secretary, went to the vice chair, and then served as 2 terms as the two-year terms as the chairwoman. I started Cheryl Cosley and Associates in March of 2019. Been in housing since 1990, so a really, really long time. And I provide training and technical assistance through the lower 48 and Alaska. So I travel extensively. I was just looking October. I am gone every single week. So if I'm not virtual, I'm out there usually. So thank you guys for letting me continue to do what I so much enjoy doing. This is the last class I'll be doing with NLC till like the middle of next summer. So good luck to you all. Stay safe, and here we go. So the objectives again, explain the intake and the application process. We're going to talk about the collections today. We hit on verification requirements, staffing, adjusted income. We've been busy throughout that 5 days, and presentations, exercises, materials, examples, had you guys answering questions all the time. I think you got 11 today, so be ready. And these are our reference materials, these sample materials you can't really get anywhere else. So look at them and perhaps grab them if they strike your fancy, I guess you would say. So this is what we've gone through in the last couple of days, and we're going to hit on occupancy standards, some other programs, lease management, lease compliance basics, counseling, and we'll end with collections. So occupancy standards. So this is the water looking at Canada. That's how close we are, and we have a lot of 1,000-footers that go through that area. So it's a beautiful area this time of year. Already it's starting to get cold. So our minimum occupancy standards. First of all, does your applicant meet the definition of a family? Does the family's income fall within the income limits you have set for that particular program? Okay. Remember, no matter what, you can't charge them over 30%. I shouldn't say no matter what. If they're 80% or below of median income, you are not allowed to charge them over 30% of their adjusted income. And then you have to decide, is that applicant suitable for your program? Can they meet the requirements of whatever you are offering? Our other occupancy standards are, what type of family are they? Those characteristics. What type of unit do they require? Should it be, a rental or a mutual help or a low rent or a rent to own or, whatever program you are offering? Some common types: an elderly family, 62 years of age or older. Your near elderly family. Remember, you got to decide in your A&O policy, even if you have baby elders or near elders, are you going to give them that elder deduction? So you have to specify at what age they can get that elder deduction, okay? Are they a person with disabilities? Are they a single person? We have lots of different family compositions. So one of the most difficult aspects we have as selecting families for housing is where are we going to put them? What size house are we going to give them? Are they young and still having and enlarging their family? Are they pretty much done having their family and they're starting to, be college age and moving out on them? So what size unit do I give them? That family is going to increase and decrease over time. If it's a rental unit, you have to let them know up front. Should we have you in a unit that is not, really specific to the size that you need, we might have to ask you to move units. And you got to let them know that, it may be necessary to anticipate the size of the family to avoid having to move them, to a larger or to a smaller house. A family in your rental program can be moved to a larger or smaller during their lease period if that family size changes and there is a waiting list for that particular size unit that they're in. It is never, though, appropriate to place a family in an overcrowded situation in anticipation of that family size decreasing in the future, because it might not happen, okay? A lot of the things we did with our mutual help program was if they, had a 3 or 4 bedroom house and then it just ended up, mom and dad in there, they would oftentimes come and ask us to buy the unit back, and we would buy it and then help them try to get a smaller unit and purchase that. When you do that, you're always going to encourage them to keep those units up, always do your inspections right up until the time that, it conveys over to them. So, those units are in good shape in case that kind of situation occurs. And normally you can purchase a unit cheaper than what you can actually build one for, even if you're, bringing it right back up to new. Just because of the price of materials and things like that being cheaper at that point, and all of that. So you take all of that into consideration. That unit size, there is no set requirement to determine unit size. It's you and your management, your policies, that you're going to consider, and make those decisions. You're going to look at the number of people in the household, children to be born, adopted, taken into custody. Is the family going to require a live-in attendant, or do they have any? You got children away at school that are going to come back. Bedroom needs based on health or medical. Sometimes one person needs the whole bedroom to themselves. And the possible growth potential of the family in a home ownership, especially, situation. So occupancy review, addressed in 203 and 207 of the NAHASDA statute and at 1104 through 110. The purposes of an occupancy review is to ensure that you as a recipient comply with the requirements of section 203 and 207 of the statute and your own policies and procedures. Sometimes we'll get a finding and it won't be for breaking the federal law. It'll be breaking or not adhering to our own established and adopted policy. Okay. So your lower income family, the reviewer is going to look, they're going to determine if the participating families, again, were low income at the time they entered your program. They're going to also look for proof. Do you have files supporting documentation that verify their income? Do the files have supporting documentation verifying income prior to providing them perhaps emergency assistance? Does your tribe, does your TDHE, does your admission policy state the families can continue to participate in the program if they subsequently become non-low income? So those of you that were in the policy and procedures class that I did last week, and I believe it was maybe day 1 or day 2 of this week, we talked about that. That A&O policy, you have to determine if you're going to let or continue to let your participants stay in your program if they are no longer low income. It's not illegal, because if they were low income when they came in there, you have to decide what you're going to do with them. Put it in your policy and also list, are you going to charge them more? Because when they are no longer low income, you can charge them more. Okay. If you're going to ask them to move, give them sufficient time. It's not quick, usually, to be able to move a whole household and to find a place to go. So, if your participating families are not low income, do your files contain documentation that verify that the tribe or TDHE has, determined there's a need for the housing that cannot be reasonably be met without your NAHASDA assistance? Has the tribe used less than 10% of their annual grant amount to assist with families for, the incomes between 80 and 100%? If they used more than 10% of the annual grant amount, did they obtain HUD approval? If you assisted families whose income is over 100%, did you obtain prior HUD approval in writing? Okay, so they don't count for your 10% authority if they were low income when they came into your program and they, income increased while they were there. But if you let them in and they weren't low income, then it does. So your other eligible families, do your files contain documentation that verifies if you've determined or the tribe's determined that and documented clearly the presence of the family on the reservation or your Indian area, if they're essential to the well-being of your Indian families or your Alaska Natives, the need for housing cannot be reasonably be met, again, without your block grant assistance. Those are the things that you have to certify to when you're helping an essential family. Law enforcement's got another couple of provisions. They have to be arresting officers. They have to be employed full-time. You have to make the determination that their presence could deter crime. Okay. The other ones, it's dealing with over occupancy, basically. And does your tribe have a definition for essential families in its admissions and occupancy policy? You should have, like I said, you need to address that there. I guess I jumped the gun. If it is a law enforcement officer, are they employed full-time? If they are full-time, are they sworn to uphold the law and make arrests? So they have to be an arresting officer also. They can't be a dog catcher. Has the tribe or TDHE determined that law enforcement officer's presence may deter crime? So they will review participant selection practices to ensure they are in accordance with your procedures that you have listed within your A&O policy. They will review the minutes of your Board of Commissioners or your tribal council to ensure compliance with the selection policies and procedures, that there's no undue influence, that they aren't asking you to deviate. And they will determine, they're going to determine if Native American status is verified. Okay, remember we had that discussion yesterday. We get the money on behalf of low-income Native Americans. That's why Congress appropriates that money. So review the requirements regarding conflict of interest. Determine if the recipient has a conflict of interest policy, if they've included conflict of interest provisions in their policies, if they are notifying HUD, if a person who participates in that decision-making process, who gains inside information with regards to NAHASDA, if they're provided housing-related services, the nature of the assistance to be provided, the basis for selection of that person, and if you are making your public disclosures. Remember the thing you put on your wall? We talked about that yesterday. So, home ownership and rental program, from a sampling, they'll review home buyer and rent payments to determine if the practices comply with, your tribe or TDHE's policies, with NAHASDA, with the regulations for computing payments and establishing rents. They will review income eligibility verifications to determine if they were income eligible at the time they entered the program. If you're doing recertifications, as required, that third-party verification is obtained if possible, and that your practices are consistent with your policies. Okay, that's huge. Don't put it into policy if you're not going to do it. So review the lease, the home ownership agreements to determine if they comply with the block grant regulations. They cannot contain, they're going to look to see, do they contain unreasonable terms or conditions? Did they require the recipient to maintain housing in compliance with the applicable housing codes and quality standards? Did they require you to give a period of time established by tribal or local law for written notice of termination of the lease? Did they state that a resident has the opportunity to examine any relevant documents, records, regulations related to their eviction or termination prior to any hearing or trial? They want to make sure that you are doing that. And that is contained within your A&O policy because of the fact that it's legally binding that you do that. Did they note that the recipient may not terminate the tenancy during the term of the lease except for serious or repeated violations of the terms or conditions of the lease, violations of federal, state, tribal, or local law, or for other good reason? Did they provide for the recipient to terminate the tenancy of a resident for any activity the resident, a member of the household, or any guest or other person under the control of the resident may be engaged in that threatens the health or safety of, the right to peaceful enjoyment of the premises by the resident or the resident's employees? Okay, this is the way that, the safety of your housing staff is taken care of. Threatens the health or safety or right to peaceful enjoyment of the premises by persons residing in the immediate vicinity of the premises. Includes criminal activity, including drug-related criminal activity on or off the premises. So you don't have to have the incident take place in the unit. If it is a violation of law, drug-related, or, it could happen off your premises. It could happen in the neighboring town. But you have to have all of this stuff listed there. They're going to look at what they call your tenant account receivables. So that's called a TAR, the abbreviation. They're going to go and identify the current dollar amount and percentage of total TARs. That's something you guys need to be tracking. This is really important. So when HUD comes in, they do their monitoring and they will give findings, and they will also issue concerns. There's some things they can't issue a finding over, but they can issue a concern, and you still have to answer the concern. So it's just as good as a finding in my mind, or just as bad, you would say. So your tenant account receivables, you need a good collection policy, and you need to follow it. You follow it regardless of who it should, apply to, unless there's an agreement in place, a payback agreement or something. You just do it. Same thing, it doesn't matter who you're talking about there. You do it blind. This is what happens on this day. This is what happens on this day. So your TARS percentage equals the total TARS divided by the total tenant revenue due, including rent and other charges. Okay. High TARS is not a violation of the statute or regulations. Therefore, a finding cannot be made in that monitoring area. Instead, high TARS would be a concern. So as I said, you still got to answer it. So this is the scale. Something to keep in mind, maybe take a screenshot of so you have it for further reference. 0 to 9% is actually very good because you can never collect 100% of what is due to you. You just don't see it. 10 to 24% is fair. And I think 25% of my rent roll almost not collecting would be a horrible thing, but it's considered, fair. Once you hit that 25%, just to the halfway mark, it's poor. Very poor is over the half the people in there. And this happens. When I took over my housing authority, there was one project that had $10,000 balances. And it was really, really important because HUD cut off our money, cut off the subsidy, did everything. When I came in, that's what it was like. The tribal chairman was running the housing authority, trying to get it back up to to par, and we started collecting rents, started building houses, started doing maintenance. And we got the majority of that money, and those TARs paid all the way down. But you have to run a good program. They didn't like me very much when I first came in. I had Dobermans in my backyard, on the ends of my driveway, So if the recipient, are you abiding by your occupancy policy when it comes to rent collection, repayment plans, eviction for non-payment of rent? Does the recipient initiate counseling when a tenant begins to lag in rental payments? If the recipient has a down payment assistance program, does the recipient have policies that address the requirements for this type of assistance? Do you have an application process and select recipients from a waiting list? Remember, I told you got to have a waiting list. HUD requires it. Determine whether the recipients for your down payment assistance are eligible. Are they low income? Are they Native American? Did you determine whether the home being purchased was within the TDC limits? Now, we didn't discuss TDCs during this course. That's called a total development cost. You can just put it in the search bar under the program guidances or the PIH notices. I think it's a program guidance though. And there was one in 2024. And that will tell you, you just go to your area, how much you're allowed to spend on a home. We're supposed to build moderate housing. So they're going to check to make sure that even when you're giving down payment assistance, that they're buying moderate housing, okay? Is there documentation to demonstrate that there are no lead-based paint issues? Did you give down payment to a house that's full of lead-based paint? Is there a binding agreement to ensure that the home remains affordable for a period of time? A lien on the property is also appropriate. This is speaking to our useful life and our binding commitment requirements, and we're going to talk about those today. Okay, because we have slippage in Indian country about those. So our first question, let's see if I could shrink this without getting kicked out. NAHASDA determines unit sizes for families. True or false? Trying to make sure that we didn't get kicked offline, and that's her telling me that. Could get worse. Okay, guys, come on. NAHASDA determines unit size for families. A couple of you got to answer me. Okay. Well, then the answer is false. NAHASDA does not determine the unit size. So our other program and A&O requirements. Your admissions and occupancy policies apply to your housing programs in general. Recipients have created additional programs which generate unique requirements. The following represents examples: down payment and closing cost assistance, tenant-based rental assistance, housing rehab assistance, homeowner loan improvement assistance, mold remediation assistance, weatherization, emergency assistance. So there's lots and lots of different programs that you can offer with those NAHASDA funds, but they all have rules. Your down payment and closing costs establish policies governing the eligibility of participants and the delivery of that assistance. Program design considers the following factors: mortgage qualification, credit qualifications, deferred loan or useful life, the amount of the assistance, grant assistance or loan. What's it going to be, a grant or a loan? Do you have availability of existing housing stock, or is everything going to have to be new construction? And what are your affordability ratios? Lease purchase criteria could be different, could require pre-qualification waiting periods to ensure that they are committed to becoming mortgage ready. Establish option periods based on when the applicant can receive that mortgage readiness. Could be a rental with an exclusive option to purchase. It requires a more in-depth analysis of the income, the education, than anything required for your rental projects. And your selection process is going to be a lot more rigorous than your rental. Now, rehab, you're going to do that rehab while it's owner occupied? Is it an emergency? Are you going to offer modernization? Are you just going to fix essential major repairs? Are you making sure that they have insurance on that house if you're utilizing over $5,000 in NAHASDA funds? Do you have that useful life document? All of your binding commitments, everything there that you need. Are you going to provide any type of maintenance counseling? Is it going to be a loan? Is it going to be a grant? Are you going to give priority to seniors or vets? Are you going to look at your oldest homes first or the greatest need, because of the threat to health and safety? A lot of different criteria, and it's better to really, really think it through than jump out of the box because you want to offer the program, because it's hard once you've opened Pandora's box to close it back up when you discover that we probably shouldn't have done it that way. You always have that person saying, you did it for them, why aren't you going to do it for me? So a checklist for rehab, step 1, eligibility. Are they income eligible? Did they give you a consent for release of information? Did you do your verifications? Did you make sure that they are the true owners? Why would you do a rehab on behalf of a Native person for a house that is not owned by that Native person? I've seen situations like that. I highly recommend that they don't. That money is for low-income Native Americans. Define your scope of work. Your scope of work is, abbreviated, is called a SOW. And in those of you that have taken procurement know all about those. You have to inspect that property, prepare your scope of work, make sure your environmentals are done before you spend any money. Have to pay attention to laws by the Department of Labor, Davis-Bacon. Anything over $2,000, if it's not your tribe or your housing entity, depending on how you are formed, doing that particular work, you have to utilize Davis-Bacon. Have you done a cost analysis? Are you following the proper procurement? You have somebody, you can't just give them the money and hope the procurement is done right, because it's your money and you have to follow the procurement laws. The budget, who's going to follow that? What happens, you can't let that get out of hand, so you have to manage it. And then the insurance, like I said, those insurance requirements. You execute an agreement, meet with the applicant, review the documents, execute your useful life binding commitments, make sure the binding commitments are signed, with a BIA, register deeds, whoever, depending on what type of land status that is, and you commence that work. Somebody's got to do inspections, make payments, final inspections, payment, make sure you keep retainage all the way through so they'll come back, and a certificate of occupancy if you have to issue one. That final process is, to record that lien. So a repair agreement, another important document that you might wish to use or develop as a home repair agreement. There's a sample in the reference materials. The agreement should include provisions that comply with NAHASDA useful life and insurance requirements, and those documents are also in your reference materials. Weatherization programs, they have a lot of the same similar considerations as rehab, but additional questions also need to be asked to determine the extent of the assistance that is required. Is this your primary or your secondary heating source that you're trying to repair? Or, what type of appliances? Are you using gas or are you using electric stoves? Things like that. Do you have any structural deficiencies? Do you have a consent form to see their utility usage data? Weatherization education requirements, property value information, property standards requirements, warranty of those products, useful life and insurance requirements, and your income restrictions. We used colleges that actually they came from Chicago, but that's where our EWONAP office is. And they did blower door testing even here for us. So because of our really cold temperatures, It's really interesting, and you can really find out what type of a product and what you need to sink your money into. So your lead-based paint, if those block grants are funds are used for rehab, acquisition, tenant-based rental assistance even, or provision of assistance to households to acquire existing housing, down payment, homeowner rehab, you have to make sure if that house was built before January 1st of 78, that it contains no lead-based paint. You have to follow the regulations on lead-based paint at 24 CFR 35. So the insurance language, basically, the intent of the guidance, and this is the one that you have to follow, 2014-03, is to provide block grant recipients with direction on when insurance is required, what insurance requirements apply, when is insurance adequate, what insurance requirements apply to your contractors, your subcontractors, what other insurance requirements apply under NAHASDA. So when is it required and in what amount? Insurance coverage is required for housing units owned, operated, or assisted, okay, with your block grant funds. Adequate insurance is insurance in the amount that will protect the financial stability of your block grant program. It means the recipient's housing units, privately owned housing units assisted with your housing funds, have to be adequately insured for one of the two time periods listed below, whichever is longer. The useful life, so that's the affordability period of the recipient or privately owned unit, so it depends on what you've picked. Your useful life is, we're going to talk about that in a minute, is listed in your IHP. The term of repayment or forgiveness agreement for all or part of the IHBG assistance for privately owned housing units. Housing units assisted with block grant funds have to remain affordable for their useful life as determined by the recipient. That affordability period, you as a recipient have to have means of ensuring their investment during that period. As long as the useful life affordability period has not expired, the block grant assisted housing units owned or operated by the recipient must be covered by adequate insurance. Insurance for housing can be either a purchased insurance policy from an insurance provider or a plan of self-insurance. Recipients may not be required for insurance on privately owned housing assistance with block grant funds if you have no risk of loss or exposure, or the assistance is in an amount of less than $5,000. Unless repayment of all or a portion of the assistance is part of the assistance agreement, okay, and we have, the useful life, that's what it requires. The recipient has to take steps to insure the units in order to protect its block grant investment. The protection can be provided in a number of ways, including purchasing insurance for housing units that are owned, operated, or assisted in an amount that is adequate to provide for replacement costs to protect your investment. Have your assisted private homeowners provide proof of replacement insurance for the useful life of or that period of the assistance received. Purchase insurance for privately owned housing units in the amount of the outstanding balance of the block grant assistance provided. Just remember, if you provide it for one, they're going to kind of probably expect you to provide it for all. So when would housing units not have to be insured? Well, if you provide $3,500 in emergency assistance to a private homeowner and the assistance is not subject to a repayment of any kind, then no insurance requirement would apply. That's because usually $5,000 is the threshold. Example 2. When must housing units be insured in accordance with the useful life affordability period? If you provide $25,000 in down payment to a private homeowner that includes a mandatory 10-year useful life for the property, a 5-year repayment clause, then the insurance requirement described above would apply for 10 years from the date that that assistance is provided. So useful life, this is the most commonly used one. It was a home example. And when we were all required to start listing our useful life, most people just kind of cut and pasted that example. Okay. Now, for a long time, I didn't see any places that deviated from that. In the last year, though, up in Alaska, I saw higher ones. And in parts of the country where they have really, really high income, they're surrounded by high income people, like in Massachusetts and those areas. I imagine Santa Fe has got some pretty high amounts out that way. So your Pueblos actually, depending, could probably crank those up a little bit. But this is the one that is most commonly used. So whatever you put in your IHP, and that's where you have to go find it. I've asked people about their useful life directors, and they'll give me this blank look, and I'll say, can I see your IHP? And then you go to there, and there it is. And it's like, this is what you said your useful life period is. And they don't even really realize what it's used for. I was very skeptical of it when it came out. I got to be honest with you. It's like, I want to say 100 years. My assistant looked at me, and I was thinking, I was looking at current assisted stock though at that time. What if they cut off the money when you come to the end of your useful life? And that's what I was thinking backwards, protecting those funds. So there's your example that is most commonly used. It's in your Indian housing plan. Guarantee they will not pass your Indian housing plan without something in there. Okay. So you can change it and see if, I think if I was going to do that, I would probably turn in my IHP, then change it, and then turn it in again and see if they would, we would like to see if this part will fly, or just straight out ask them, So your useful life, there's 2 program guidances about useful life. One that has some examples in it, and then one has additional things in it. So you could look at both of them. I always did. The 2020-02 is the most current one. It talks about what is satisfactory to the secretary, what constitutes an acceptable binding commitment. The guidance of 2014-09 actually has some sample stuff in it. So utilize them both, but take a good look at your useful life stuff. It's a huge part of your ANO. And it applies to, even if you don't have housing, if you're spending NAHASDA dollars, okay, that's why you need to know how to come up with the right amount of their income. You're helping them with TBRA, or you're giving them modernization or rehab or whatever, this would apply still, okay? So you have to have a useful life policy and things like that. So this is what the guidance looks at for the useful life and binding commitments. Requires those units must remain affordable for either the remaining useful life of the property as determined by the secretary. So whenever you see that language, as determined by the secretary, that means if you turn it in and they approve it, the secretary has approved it, okay? HUD is the secretary basically, and as long as that document is, approved by your HUD office, it's deemed approved by the secretary. Such other period that the secretary determines is the longest feasible period of time. Requires a useful life description in your IHP. It applies to new and rehab units. Does not apply to your mutual help units that were built with 1937 Housing Act funds. Now, if you duplicated the mutual help program and you're doing that with NAHASDA funds, it would apply to those units, okay? So it's the period of time which the low-income rental housing, homebuyer housing has to remain affordable as required in sections 205A2 and 209 of the NAHASDA statute. Your affordability period when block grant or Title VI funds are spent on a property and investment is made for low-income families. The return on that investment is the period of continued use during which that property needs to be available for use by low-income families. So I'll give you a scenario to kind of explain it for those of those that aren't familiar with that. I had a staff member and I asked her if I could talk about this. She was married to a non-native. They purchased a house off of the reservation. We give them down payment assistance. She got divorced. She moved back to the res. They sold the house. A non-low income, non-native bought it. They still owed money on the time period hadn't elapsed. So they had to pay back the housing authority. Now, there is a couple of different things that you have to make a decision about. Let me see where it is. Your single recovery amount or your prorated amount. A single recovery amount, let's say we give you $10,000 for 10 years. Okay. In the 9th year, you would still owe $10,000. If your program said that you were going to use a prorated recovery amount, and that's what our housing authority did, in the 5th year, you would only owe $5,000. In the 9th year, you would only owe $1,000. It would decrease like $1,000 a year. So it's prorated depending on how much money it is and the length of time. A single recovery amount, you owe that whole amount if you make it all the way up to 2 days before it's supposed to expire. Okay. So that's one of the things that your governing body is going to have to decide when it comes to that. So your future use is your affordability period for, or the useful life for that property. So you have to figure out what you're going to use in there if you don't like what you have there now. And you know, that affordability period has to be established for your housing units constructed, acquired, or rehabbed, to make sure that it's a low-income person that benefits if you do sell that property. Minor investments, the affordability period can be a nominal period, but NAHASDA requires some period be designated and then it be secured with a binding commitment. So let me go back really quick. Usually under $5,000, it's 6 months. It says it has to be there, so I don't know if you can shorten that up. 5,001, you know, so it's you can see exactly, you know, if you want to try to move those amounts around, if they will allow it. I wouldn't move them too far, but if you are in some places, you know, those amounts won't be enough. They won't be sufficient. You know, Alaska, you ship and you fly everything in. If you're in a really, really wealthy part of the United States, my friend used to run a Quinnawampanoag, okay? Martha's Vineyard. Everything comes over by boat in the middle of one of the richest places, you know, and their reservation's smack dab in the middle of it. Higher amounts there. So depends on where you're located. So if it's less than a year, it's not necessary to record the written use restriction for purposes of complying with NAHASDA, but it is a good business practice to record that for purposes of giving notice to subsequent purchasers. A binding agreement satisfactory to HUD, a written use restriction agreement developed by the recipient, placed on an assisted property for the period of its useful life. And as I said before, the Program Guidance 2014-09 actually provides sample binding agreements. So examples, you know, fee land, there's, I think, 7 of them in there, depending on what type of property is, if, you know, if you're on the reservation or off the reservation, and if you're using a single recovery amount or a prorated recovery amount. So it requires the full amount. Fee land, single recovery amount, requires the full amount of block grant Title VI assistance to be refunded, returned to the tribe or TDHE should the property be sold or transferred prior to the end of the useful life or affordability period. Now, if another native or low-income person buys that, you just extend it from that amount. You don't have to get that money back, okay? Then that other person. So that's why you have to track that on there. Fee land prorated recovery amount. The amount invested in the property can be prorated over the life of the restriction. In the event of a default, only the current prorated amount must be refunded. So they recommend that you keep a spreadsheet with property address, owner's name, how much money was spent of your block grant, affordability period assigned, the date of assistance, and the form of the binding agreement. So this is something, this is one of the things you find in the self-monitoring. This is for the down payment assistance program, but you could use the same form. Who is the occupant? What was their date of application? Did you get proof of enrollment? What was their annual income at the time of the application? What was the family size at the time of the application? What was the income limit at that point? What's the difference? Were they eligible? How many bedrooms? What's the purchase price? Because it's a down payment assistance program. Is the price within the total development cost? Did you, is a verified check issued to the mortgage company? We're not allowed to issue those to your tenant. You can put the mortgage company and your tenant on there, but you cannot just issue it to your tenant. You'll get in trouble because people have walked with those. The date of assistance, is there lead-based paint there? Is there a useful life agreement? Is there insurance on the home? So these are all the things they're going to check. And this is just the down payment assistance. So it's a really good idea when you get into your job a little bit more, pull down the monitoring things, the monitoring agreements, anything to do with admissions and occupancy, and know that these are the areas they're going to check you if you offer these programs, okay? That way you protect yourself. So enforceable agreements, participant agreements, liens on the property, that it's recorded. Is it a forgivable loan agreement or a conditional grant? So that is, in a nutshell, real quick, some of the requirements about useful life. It is an area of slippage within Indian country, okay? Try to focus on that. If you're not, if you don't have those out there, and it's usually if you help them with anything over $5,000, okay? So make sure somebody's paying attention to it. What happens before a project starts? Well, you need to do needs assessment, community planning, identify your needs, your programs, your facilities, your land. Get an organizational commitment from your governing body, your tribal council if you can, in a resolution form. That way, if they roll over, my tribe has elections. They're coming up right now. Got a ballot sitting there. Absentee, because I'm going to be gone. And we roll every 2 years. They haven't changed the Constitution yet. So it's always a good idea to get the buy-in of the current tribal council, get it in resolution form whenever you're going to build or take on a new project. That way, when another tribal council comes in, you can say, these are my marching orders. I have a resolution. And it just, makes life easier. So that organizational commitment. Identify human and financial resources. How are you going to run it? Who's going to run it? Do I have the money? Do I have the people? What type of commitments do I have? And get an official resolution and keep those official meeting minutes. Your analysis can tell you, what can the people afford? You can't build something if your tribal members can't afford it. What are they willing to pay? What is the needed household size and composition? So I really addressed, I had one chairman that was in place for a long, long time, and he wanted home ownership, and we provided a lot of home ownership. I mean, hundreds of units, 200 units at least. And mortgage products. We, would run the credit checks. We would use them if they had little or no income, the rural development projects or product money. If not, they went to 184. If they had really good credit, a conventional mortgage was the cheapest way to go for them. And we would one of those 3 slots basically, and then provide the down payment assistance. We had the IHS program through our office, the land through our office, the utilities through our office, pretty much one-stop shopping. And then it got to the point where there was a lot of like 20, 24, 25-year-old, especially men, still with their parents, because we didn't have any, they didn't qualify for a house all by themselves if they weren't married. So that's when we started focusing on, okay, we need some apartment buildings and some smaller units, because so much of our tribal enrollment are people were of childbearing age and in that middle range there. You know, they were becoming 18 to 30, and there was a huge amount of them. So we had to change that focus. And smaller units, 3 sets of apartment buildings, actually. So that's what you do. You find out what your need is, and it'll change over time. When you address one, well, then another one's going to come into focus. So are your rental revenues going to meet your expenses to operate and enable payment of a mortgage? If it's a mortgage product, home ownership, what price and resulting mortgage will people pay? What's your affordability gap? And what is your reality gap? You can't sink them, you know. You got to give them money to continue to live and buy their other things. So what type of housing meets people's wants? You know, what size home do they want? What kind of amenities? What kind of features? And given what they can afford, are you willing to pay? What kind of program are you going to provide them then? So those are all those questions that you have to ask. Methods of assistance. Are you going to do a subsidy for a rental? Is it going to be a grant? Is it going to be a loan? Is it going to be a no interest product, a market interest, or a reduced interest product? That takes away from the money that you have to run your other programs. Remember, when you have that out there, are you going to allow sweat equity? Okay, sweat equity is a scary thing to a director unless you have a certified electrician or a carpenter that can go work on that house. When it comes to sweat equity, the mutual help program used to require it. We had them clear lots. We did that. And then finally, the tribe started just giving an acre of land away for every participant and valued it at the $1,500 requirement to meet the sweat equity requirement, because of the fact that you have worries about insurance and things like that also. And then other things that you have to track while you're trying to build a housing project. So you have to be careful with that one. Are you going to offer technical assistance? So one of the things we realized shortly out of the gate was we were almost having to build the houses for the people that got the home ownership projects, the monies, because they didn't have any idea. And you can't just hand the bank or get some money, you know. You have to have some ownership and decisions to make and contractors to get and where you're going to place the house. And there's a lot of steps to that. One contractor has to come before the other one. So then we actually learned, okay, we don't have the time to be doing this. I didn't have the time as the ED, nor the staff. Let's make sure that we have really good general contractors that come in here and help them with that. So they realize that. So there's all sorts of components that you have to build in there. If you utilize money from a lot of different places, which is great if you can get it, there's going to be stricter rules depending on where you get it from, and then you have to layer in those requirements. The bottom line rule is always use the strictest requirements you have to cover yourself, but special needs of your funders, credit issues, documents, income limits of different programs. Low-income housing tax credits has a different income limit than a NAHASDA unit. Everything's different. You know, targeting, income targeting, minimum incomes, affordability periods, asset calculations. There's all sorts of different components that come in there. Okay, is somebody going to try to answer a question today or no? What is the maximum rent for a family with 0 income? Anybody? I'll give you a couple of seconds. Is there anybody in my class? Yes, Candace can hear me. You had me thinking that I was talking to a screen. I've always had that nightmare that I'm teaching away and I'm offline and I don't know it, you know? So, okay, good. Our policy has a minimum of $50. Okay, but remember, Candace, the rule of thumb, okay? 0% or 30% of 0 is 0. So if that $50 is more than 30% of their adjusted income, that's illegal. You'll get in trouble. Okay, so be careful there. So 0 is your answer, guys. No more than 30% of their adjusted income. So there's actually 2 correct ones. Per capita and Christmas bonuses is included for all tribal members. Okay, so if you're including that as income, then you know that they have that minimum income. So you've got a safety net of sorts. Okay. As long as it's spread out, if you spread it out over the year, it comes out to over that 30%. Okay, just have somebody do those calculations to protect yourself. Okay, what is the maximum rent for a low income family? Fair market, 30% of adjusted income, market value rent. Low income family. Good job, guys. Yay. Okay. Can a tribe or a TDHE charge a home buyer for maintenance? Yes, no, or it depends. I'm waiting for Miranda. She's typing before I say anything. So if they have their own insurance, yes. Okay, insurance really doesn't have anything to do with it. A low rent tenant, and actually like a mutual help tenant, you're not supposed to charge for any wear and tear. Okay, you're only supposed to charge them for damages. Now, we did inspections of our home ownership units until they conveyed, and we would require them to fix damage. Now, if they didn't have somebody that could fix it, we offered our maintenance staff, and we had a set price per hour, and we pretty much had a whole chart of this is how much a toilet replacement, this is how much a wall is, this is how much drywall is, this is how much painting is. And our maintenance guys would do that, and we would charge their account, and then they would pay them back. But one of the reasons for that is because we're so far away from, we don't have a lot of handyman in this area that do things like that. So that's what we would do there. Okay. So you can charge them. They pretty much have to agree with it, or it has to be a situation where you got this long to fix this, and if they haven't done it, then you're going to send somebody in and bill them. Okay. So when can the tribe or TDHE charge a renter for maintenance? And I just give you the answer to that one. Sorry. See if you were listening to me. Renters pay all maintenance, never, or when the damage is beyond normal wear and tear. Anybody else? Okay, I'm moving along. Good job, Ben. Good job, Miranda. Yes, when the damage is beyond normal wear and tear, you can charge a renter for maintenance. Okay, lease management. For those of you who weren't there, that's how I get out of the upper peninsula into the lower peninsula when I fly or whatever. And sometimes we can't get across because of the ice. And it falls down and they close the bridge. When I came home from Florida last year, that's what happened. I got stuck there for like 12 hours in a line. So a dwelling lease can be for a rental, a lease to own home ownership program. Whenever you create or change or alter a lease, your lawyers should look at it. Okay, a lawyer should look at it. It defines your contractual obligation between your residents and you as a recipient. There's important inclusions in your leases: the name of the parties that are involved in there, the unit location, the amount and due date of the monthly payment, the amount of the security deposit, the utility services, the ones that you provide, each party's obligations, housekeeping standards, inspections, termination clauses, clauses on drugs and criminal activities, pets, parking, different policies that you have into place, service animals, hoarding, could actually be on there. Okay. Residents' right to use and the occupancy of those premises, the notice procedures that you have to use, recertification, changes in household payment, household composition, tenant responsible for utilities, for solid waste, or abandoned vehicles, whose court has jurisdiction, did they receive their policies, tenant caused damages, charges, corrective actions, entry of a dwelling unit during tenancy, grievance procedures, inoperable vehicles, residents' maintenance responsibilities, evictions, appliance use as intended, not heating the house with your cooking stove. Perhaps, the hanging of blankets and windows instead of curtains. There's lots of things that could be in there. Possible lease addendas. So I spoke to this when we were talking about running a criminal background. Sometimes when they would come in front of the tribal council, they would have an addenda prepared in order to allow them to move in. If they didn't want to sign the addenda or they breached the addenda, they were immediately out. It's like a do not pass go. That was a requirement of that lease. And those would be the conditions that they would take somebody that didn't pass their criminal lien. They would come and plead their case in front of the tribal council, and they would develop certain lease addendas. No alcohol in the unit. Nothing other than a traffic charge. No guns in a unit. No any type of domestic violence complaints. They could, based on the situation, they would develop lease addenda also. So that's another thing that you can do. Always, those have to be created by a lawyer though, okay? Lease addenda could be things that have to change periodically, the list of occupants, the requirements to maintain essential family status, the notice of payment and collection procedure, the rules of occupancy. There are certain prohibited lease provisions. You cannot require a confession of judgment. You cannot seize personal property in place of rent. No exculpatory charges. You cannot require a waiver of their legal notice or their proceedings or a waiver of a jury trial. Can't ask for a waiver for their right to appeal. This is one that my staff breached. A requirement to pay cost of legal action regardless of outcome. So they were immediately, for eviction and things, putting the court fee or the fee for the court filing on to the tenant file. I said, you can't do that. Well, what do you mean? I said, you can if you win the case, but if you don't win, you can't charge them for bringing there. You didn't win your case. So, requirement to pay cost of legal action regardless of outcome. Okay, can't do that, guys. Home ownership agreements allows the home buyer to purchase the unit, lease the unit with an option to purchase, specifies the resident's obligations, pay for required maintenance and utilities, capacity to pay a monthly homebuyer payment. It could help, those policies require mandatory housing counseling to help them understand their financial and social responsibilities of home ownership. They're different than, that rental. Find out if they have that ability to contribute, land, materials, cash, labor. There's different things there. So your orientation lease topics, this is the one that I said you got to spend some time during that one. You don't hurry them, and you try to do it not when you're handing them the key, at least a week in advance, okay? Because they're, like I said, they're going to be thinking about, I got to buy a garbage can. I have to buy a shower curtain. I have to buy this, everything except what they're sitting in there supposedly discussing with you. So regardless of that program type, an orientation for any applicant family should include a thorough review of the applicable lease agreement. Many recipients now include basic housekeeping as part of that orientation. Helps all the participants understand the standards used for inspection, how to meet those standards. Some recipients include the basic cleaning supplies. They give them a basket, okay, full of cleaning supplies as part of a welcome basket for their new participants. Now, you don't have to go as far as a basket, but if it's actually any new, whether it be a house or an apartment, the one that your maintenance guys will love you for the most, give them a brand new plunger and put a bow on it. This is part of your welcome, because most first-time people don't have one of those. And what are they going to do? They're either going to flood the floor or they're going to call the maintenance guys. And that is an allowable expense for you. But like I say, some recipients include the basic cleaning supplies necessary as part of a welcome basket for new participants. In addition, to those housekeeping standards, all participants should know when to call maintenance. I used to tell them, right now, 3:11 on Friday is too late in my mind. If you've got a running toilet that has been running all week long, or it is something that is not an emergency, please don't call my maintenance guys after 3 o'clock on a Friday or on a holiday weekend coming up when the majority of them are all asked to be off. Use some common sense and respect my guys, and I would have that topic with them all the time. So the basics. Normally, we wouldn't do it during the first inspection unless we're only doing them yearly. And it's really smart if they have a kid there over the age of 6 or 7, include them in on this part because sometimes they'll remember and their parents won't. Show them where the shutoff for the water is in case something happens. If they can remember that will save your house, that'll save your maintenance guys, shut off the water, then make the call to the maintenance guys. But we would teach them things like that. Things that, there's little glitches almost in every project you will discover. The GFIs we had in one house used to shut off everything around the counter, the stoves and everything. It got to be a point when somebody would call and they would say, we have no power here. Whoever was answering the phone out front could say, well, I want you to walk to the end of the counter. You see that thing that's red and it's black? Take the end of a pencil and poke this part in. There, did it click? Now go tell me, is your stove blinking? Or we bought one set, and I have one in my house right now. If the power goes out and the clock starts blinking, when it turns back on, my oven will not work until I set that clock. Don't ask me why. But I had a whole project from them, and I got a house that did that. And this is a fairly new stove. Well, it was brand new when I bought it. It's my second one, so it's not that old. And so there's glitches that you will learn about, and you can teach them that also. So basic orientation steps are proven to save time and money in future maintenance charges and time, so using your unit as a primary private residence. They cannot sublease it. They cannot own 2 houses. These are part of those topics. When those monthly payments are due, keeping the unit in good, safe condition, cooperating with recertification and inspection. You don't do this, it's grounds for eviction. We'll terminate your lease. You have to do this. Understanding the maintenance process, understanding how disputes and grievances are handled, reviewing insurance coverage options, telling them, we're going to cover this unit for fire and wind and certain things like this, but we really recommend that you get contents coverage or renter's insurance or, and telling them that. We had AmRent here, so we would try to give them those materials also. Telling them that they're responsible for the behavior of their guest. Grandma, your grandson can get you kicked out, you make sure that if you leave town, you're out on the powwow circuit or whatever, your son's buddies could end up losing you your unit while you're gone. They need to know that. When to request the maintenance, the Friday late afternoon discussion, there it is. Okay, we have another exercise, guys. How often should your leases be updated? Never changes, whenever something in the lease changes, or at recertification. Thank you. That's our Northern Lights, Miranda. We have lots of those, but it's cold and it's usually late night. I was too lazy to get up and see them last week. But if I'm camping, that's when I really see them a lot. Okay. It's actually whenever something in the lease changes. Okay. If something happens, you should probably have them come in and redo a new lease. You don't really want to wait, especially if you just executed them or renewed them or whatever. You know what I'm saying? So, okay. Are tenants or homebuyers required to have counseling prior to move-in? Yes, no, or depends on your policy. Anybody else? Benjamin? Okay, so actually there is no requirement. It depends on your policy, and most of us require them to do an orientation. Okay, so it should be a yes by all means. Okay. Lease compliance basics. So this is like a quarter of a mile from my house. Our tribe actually runs it. It used to be ran by the Forest Service. My mom used to spend the night there when she was little. Big old lighthouse. So lease compliance topics, maintenance, recertification, inspections, maintenance requirements, 3 important documents that influence your maintenance management policy, NAHASDA itself, the regulations of 24 CFR 1000, and your own dwelling lease. Maintenance responsibilities varies by program. Rental, it's the tribe or the housing authority. Home ownership, it's usually the homeowners. Policies can require rental tenants to pay for work to repair damages beyond normal wear and tear. Could be good to include maintenance issues at, in the lease agreement. So this is a sample failure to perform maintenance clause in a homeownership occupancy agreement. Failure to perform maintenance. Failure of a participant to perform his maintenance obligations constitutes a breach of this policy. It is grounds for termination of the program assistance. Upon a determination by housing staff that a breach has occurred, the staff shall require the participant to agree to a specific plan of action to cure the breach and to assure future compliance. The plan shall provide for maintenance work to be done within a reasonable time by the housing staff in a good workmanlike manner in accordance with the Uniform Building Code. If the tenant fails to carry out the plan, the tribe or TDHE will have the work completed and charge the cost to the participant. Such charges will be billed to the participant. So some of your maintenance policy topics: what type of maintenance is it? Is it emergency, urgent, routine, non-routine services? Is it a vacated unit repair? Is it preventative maintenance? Is it inspections or right of access? Do you have a work order process? Standards of work, schedule of cost, maintenance counseling. It all begins and ends with a work order, okay? Those are really, really important. Make sure your work orders are caught up. Even if it takes rewriting them because you could only complete a certain portion of it and you're waiting on something, because HUD will look at your work orders. How many you have out there? Did you charge them for the work that you've done if needed? And did you complete that work if they were charged? They definitely look at if you charged a tenant that was moving out, that you completed that work before the next tenant moved in. Okay, those are just things I know that are looked at. Don't let that happen. Okay, so Your work order process, work assignments given to maintenance crew members on a daily basis, director or maintenance supervisor, gather the materials required to complete work, assignments gathered by your maintenance crew members, excuse me. Complete the assignment. The crew members complete their daily work assignment. Then they report on the work order. The maintenance crew members fill out, submit work order forms during the last half hour of the day, and then they get them reviewed. The director reviews the work order for accuracy. For the work order posting, the work order information is posted into an accounting system. Is there going to be a tenant charge, labor and material costs billed to the tenant A&R account? A non-tenant charge, the labor and material costs posted against a corresponding federal grant per unit cost allocation reporting, and then you file that work order form. Work order forms are filed by project and unit number. So that's a sample work order policy, how you deal with that. So your work order system provides the ability to control your work, to schedule it, to track the work planned and completed, facilitate development of a preventative maintenance plan and your capital improvement plan, and it allows for job costing, and it allows you to comply with your total development cost. Now, your maintenance is one of the largest expenditures if you have big projects out there of your budget, just so you know that. So your move-in inspections, the home condition, you have the family sign the inspection report, and you hand them over the keys. Don't give them the keys until all of that is done. Use your iPhones. Hand up the iPhone, it'll say the date and it'll say the time. When you're doing any type of inspections, my guys used to do that. They would take a picture of another guy with the phone there so you could see the date, you could see the time, you could see the hole on the wall. There's no arguing with that, you know. Look, on this date, it's here. Don't tell me you didn't do that, you know. So it's just a good way to do that. Those pictures, you know, if you use Canso or anything like that, you can store them right on the tenant file. It's very easy when they go in and they cry and, you know, at the move out, and they give us $4,000 worth of charges, and they go to the tribal council a couple of months later after you fixed everything. It's a lot easier to make your argument when you say, yeah, but these are the damages. Look at these pictures, you know. Then they're going to be a little bit more sympathetic and say, okay, these people are feeding me a line, you know. So the move in, move out inspection form, what you basically look at. So as I said, I was a director for a long, long time. And it got to the point where I kept hearing, how come I'm not getting my whole security deposit back? And I used to tell them, you're supposed to give me 30 days written notice when you're moving out. I want that house back just like you gave it to me. Or we give it to you. You know, it was painted. It was clean. You don't charge them for the wear and tear, but it's not supposed to be filth. If you have to dispose of something, it costs a lot of money. We're paying for that charge. So that unit should be close to the original condition. Like I said, the family pays for the damages, but not the wear and tear. So I got mad after a while, and okay, I'm going to give you, and this was the Bay Mills move out procedure, but I wrote a procedure, and when they would give me notification, I would give them that. Wow, I didn't know I had to do this. Well, if you want your security deposit back, you need to do this. And we started getting our units back in a little bit better condition. And we spoke to abandoned property. We talked about turning off your utilities, and what needed to be basically cleaned, you know, general cleaning in all rooms. Receptacle covers, your closets, your light bulbs should be there, you know, your refrigerator should be emptied and wiped out, your cupboard should be emptied and wiped out, you know. So it goes through all of those rooms and says, this is what you had, this is what we would like back. When you contacted the electric company, when you did that, when you did this, you know, what about that property that you leave there? Don't expect us to hold it for you for months and months, you know. This is what we do. And then the keys and the locks. Did they turn in those keys, or do we have to rekey the whole place, you know, whatever. So give them that procedure, and it made it a little bit easier. So requirements for inspections, those initial inspections to ensure the work is performed or the condition of the unit meets the performance standards. Reoccurring inspections, all units by NAHASDA owned by the tribe housing authority for which they have maintenance responsibility, all units covered by a lease purchase agreement, your 37 Housing Act rental and home ownership units. Recertifications, your scheduling can be on the lease execution anniversary date, or you can spread them out to manage the workload, or you can do them all at once if you want. That is your, it's up to you and your staff the best way to do it. Inspections, we'd wait until there was no snow on the ground. It should begin 90 days. Give them notice. Say, we're going to be doing it, dear tenants, it's that time of year again. We will be scheduling inspections for June. Keep your eye out for your notice, and we would give them that 90 days in advance so they know that, we take the time. If they had receipts or whatever, we put those in there, because you're sending out that, wasting that stamp, so those were one of the things that we would do, but we would give them notice. It's that time of year, start getting everything ready. We're going to be there sometime during the month of June, but you give them that heads up. Use your third-party verifications. We went through that yesterday. And give at least 30 days notice of a rent increase. Give them 30 days, give them that grace. But I used to tell them, you're going to get 30 days if you come in and tell me. Now, if I find out that you got an increase that affected your rent and you didn't bother to come in and let us know, that I'm going to make it effective the day that it started. You're going to lose that 30 days. So that was an incentive for them to come back and report. So your interim recertification examples, if there's a job lost, if it's a retirement, change in family composition, a birth, a death, resident moves out, changes income, they got a pay raise, their unemployed resident becomes employed, substantial increase in allowances, child care, travel expenses, they turn 62, become an elder. You're going to want to do those recertifications now. Corrective action for non-compliance. Legal action should be preceded by phone communication. Hey, is there something wrong? I noticed you didn't pay your rent, or like I said, have that staff member that's good at that, not your bougie one. That helps. Home visits, first corrective action plan, second corrective action plan letters, things like that. When you go to evict somebody, your judge is going to want to have all that stuff. If you've never dealt with them, or it's a brand new judge, because our judge is up for election right now too, that was one thing I used to go, what are you going to expect for an eviction? What do you want out of us? And well, we want these notices, proper notices, sir. You showed that you told them, showed them what was coming. So that's, one of the reasons you do that also. Written documentation is critical in the event of a legal action. Did you give them subsequent timely notice? So there's tools out there, Pathways. You can get Pathways books. Those are wonderful, wonderful learning documents for Indian country. They're for us, okay? Credit rebuilding letters, budgeting worksheets. There's a PowerPay debt reduction system. Good example out there, wpowerpay.org. So there's different things out there that you can utilize. I know for the Pueblos that are in the room, that some of the Pueblos that I have worked with in the past, there are state programs that do credit counseling for them. Because they don't have the staff to do it themselves, but there are some in your Santa Fe Pueblo area there. Okay, so exercise. Are recertifications required for home buyers? Yes, no, depends on your policy. Anybody? Okay, we have a bunch of B's. So that depends. It depends on your policy. We recertified our home buyers to make sure they were still income eligible. Okay, so do we have another question? Don't know. Are inspections required for home ownership units? Yes, no, depends on your policy. There you go, Miranda. It's basically, yep, depends on your policy. Which of these is not a reason to track maintenance work orders? Scheduling work appropriately, track cost for your APR, track cost for your total development cost. None are reasons to track maintenance work orders, or all are reasons. Actually, all are reasons. Okay, you're supposed to track, make sure everything's, appropriate. Your APR, you need to know what you spent where, and your total development cost, you're always supposed to track how much money is spent on a unit. So your counseling, your different types of counseling, it's supposed to be personal, specific, usually one-on-one, way to help your people help themselves, relationship, problem solving in a professional manner. Your different counseling topics. Are you doing homebuyer education? Is it pre-purchase, post-purchase? Is it going to be about rental assistance, self-sufficiency, financial literacy? Do they need help with debt management? I used to share my budget with some of my tenants, my own budget. I know I make more money than you, and I can't afford to go to the casino, so how can you? That's it. Just have to do that sometime. Some things could, you could talk about housekeeping, fire safety, grievance policy, advocacy, mortgage delinquencies, some of your goals, household budgeting, financial management, maintenance of that home, increase home ownership opportunities. So there's different types. You can do client intake, you can do group instruction, one-on-one. Programs combine different kinds. Certain things when you're talking finances should be done in private. Client intake, it affords the staff time to meet your family, get various consent forms, things like that. Group instructions and orientation. Group settings, you make that fun, housing fairs, whatever. And then you have your one-on-one. 90% of that counseling effort is delivered as one-on-one counseling because it's private. It has to do with that particular family. Different types: pre-occupancy, pre-purchase, credit counseling, budget counseling, post-purchase, default counseling, and advocacy. One-on-one could be affordability, their debt, their credit, their down payment assistance, recognizing predatory lending. We had somebody here that was trying to charge our tribal members for used cars and new cars in like the 20% range. I was so mad when I found out. I went to my tribal council and they They sicked the tribal attorneys on them. And they said, that's predatory lending. And if you continue to do that with our tribal members, we will sue you. The tribe will sue you. You got to watch out for things like that. Don't allow that to happen to your people. So recognize predatory lending practices, understand what fair lending is, avoiding foreclosure, and how to resolve a financial, crisis. Your budget counseling could involve short and long-term goals, budgeting to achieve your goals, and an explanation of that creation process. If you make that coffee at home, it'll cost you $6 a week. If you buy it, it's going to cost you $7 a day with a tip. This is this much over the course of a month. That's one payment for something, explaining that to them. A lot of the challenges to making the payment: too much debt, lack of stable employment, lack of savings, and lack of resources to handle emergencies. I have 2 children and they're 15 years apart. The oldest one will spend, if she was given $6,000, she will spend $5,900 of that immediately on something. Okay. The younger one, who I probably had a lot more time to spend with when I was older, realizes, and he knows he can have anything he wants as long as he works for it. He works 2 jobs to this day, but he knows to put money away because he knows there's going to be emergencies. I am the bank for the other one, so that's just depends on how they are. Your counseling barriers: slow payment, credit issues, insufficient income, high debt, slow payment, low savings, employment stability, trust properties. They don't like lending, still on trust land. Some of those common challenges, hardships meeting those housing obligations. Many families fail to make house payments in a timely manner because they don't have the resource to save money and handle emergencies. So that debt management and things like that can be difficult. Housekeeping and cleaning could be new to them. Maybe they were raised without a mom in the house. There's different programs that you can teach them how to do that also. Okay, what should be covered in your housing counseling? Terms and conditions of the lease, policies, coverings, admissions, and continuing occupancy, collections, and all could be covered as part of housing counseling. We are almost done, guys. I realize we're running late. Okay. Anybody else? The answer is D, though. All could be covered as part of housing counseling. So your collections, the purposes of your collections policy, and I've been going on that one all week long, inform your residents of your guidelines for rent collection, house payments, housing services, payment of work orders, and other charges. Make it as easy as it can be for you. I know of places that have drive-through where you can pay the rent, and they don't have to even come into the housing authority. We have or had a drop box, cameras on the drop box, envelopes there. Only once did we got an envelope full of money and they forgot to put what their name was, but we could figure out who it was. And as I explained earlier when I was talking about the tenant files, it emptied right into that room that you needed a combination to get into the room for, that the files were in. But it's a really good way so your people can pay their rent whenever they want. Or you can offer, credit card through, a website or whatever you want there. But make it as easy as you can for them. Payroll deductions is wonderful. And the tribe does it on behalf of, and that's huge. Comes right out. They don't forget it. One of the other things real quick, our staff, our tribal council, they were not allowed to be late on their payments. They had to be examples. And I would tell them that when I would hire them, and I would tell the council that. Should you be in one of our units, you have to be up to date. You are going to be the grievance board. Same thing as the staff members. We don't want them to be able to point around and say, hey, I'm not the only one. Any of you guys owe money? You want them all to be able to say, no, we are paid up in full. So that is a requirement, especially your board of commissioners. If you have a board of commissioners, you should not have them breaking any part of their lease. And they definitely should not owe you money, okay? Because they're going to be your grievance board. So your purpose of your collections policy to inform the residents guidelines for rent collection, house payments, housing services, payment of work orders, and other charges to ensure that continuation of adequate housing services while providing for safety and well-being of your residents, promote fairness, due process. Your policy should apply to residents who have entered into a lease or homeownership agreement with you as a recipient. Required monthly payments should be in the lease, definition of what a delinquent account is, the process for an extension and partial payment due to hardship, the process for budget counseling, notice of delinquency, payback agreements, and the notice of termination. Explanation of a permanent loss of eligibility for future services. If you owed us money or the utility authority, we were not allowed to help you with anything. Not allowed to take an application until it was paid in full. Process for a grievance hearing and administrative hearing. NAHASDA allows, that collection. It's critical. NAHASDA allows the tribe or housing authority to tailor monthly payment amounts to your community needs and affordability. Failure to collect your payment hurts your future housing assistants, the other people, your other tribal members, and you have legal and other collection costs, which will take away from your other affordable housing activities. Everybody has a role in collections and compliance. Everything they do can have an impact on your program success. Make all of the efforts for collection and compliance positive and constructive. If you can afford it, look at what it would cost. Throw an incentive out there. If we receive all of your payments throughout the year on time, we'll waive December's rent, and it'll give you Christmas money. I've seen people do that, so you can do things like that. Case management, collection compliance, most effective on a case-by-case basis. A model for case management, you have to have that willingness and ability to pay. The following requirements can be included in your policy: the amount of the required monthly payment stipulated in the lease or home ownership agreement. Resident fails to meet his or her financial obligations, including payment of required rent, the account should be handled as a delinquent account. The ability to meet those financial obligations is a requirement for initial admission and for continued occupancy. Small, $20, $15, $20, $25, late payments work wonders. It'll make them pay more timely. Your collection procedure: if your resident presents evidence of an inability to make a full payment, due to a hardship, your policy can allow for the consideration of an extension and the negotiation of a settlement. We didn't settle how much they owed by any means. We allowed late payments. We had repayment agreements, okay? Your extension deadline will become the new due date. Extreme circumstances can be considered in approving the extension of a due date. Such conditions could include a death of an immediate family member, a disaster that affects the financial state of the family, or you got somebody downstate in the hospital, or whatever the is. And when that resident presents credible evidence that clearly shows an inability to make a full payment, a partial payment should be accepted. A notice of delinquency sent to a resident who has not made his or her full payment by the time specified. Notice of delinquency is a written demand for immediate payment with the past due balance. The notice shall inform the delinquent resident to make immediate payment for continued occupancy of the housing unit. Upon service of the notice of delinquency, the resident has a specified amount of time to permit or remit the delinquent amount in full or commit to a payback agreement. The notice also may recommend that a delinquent resident immediately contact housing staff regarding any financial problems or unusual circumstances. The notice should inform the resident that failure to comply with the notice will result in a notice of termination. Sometimes you need to contact both spouses. I have seen over time several cases where one spouse thought everything was getting paid and the other one didn't. And you don't want to make that person homeless because this one's pulling a fast one. So, I'm going to contact your husband, or I'm going to contact your wife also. We've agreed to do this. I had a lot of with the apartments, young ladies would be brought in and they'd go to move in and their dad would bring them in. And I'm like, I used to ask them and get permission. If something should happen in the future, you fall late on your rent, or I need to contact you or whatever, can I contact your dad if I can't get a hold of you? And they would say 90% of the time, sure. And I would do that when they were late on their rent, and 9 times out of 10, dad would come and pay the rent. Now, I'm not saying that that's a good thing to do, but I got my rent and didn't have to kick them out. So I did that. But like I said, make sure that you get a hold of both of them, not just sending it through the mail. Try to verbally make sure that you talk to both spouses if there's 2 of them there, because of the fact that sometimes the other one doesn't see it. Budget counseling, could be scheduled with a resident during the period of account delinquency. While your policy should require a minimum of 1 budget counseling session prior to termination of the lease or homebuyer agreement, a series of follow-up counseling sessions is recommended. A housing counselor is responsible for providing that family budgeting and maintenance counseling. They also have the discretion to negotiate a payment agreement with that delinquent residence before that notice of termination is served. That payback agreement can be negotiated with the delinquent resident as an alternative to immediate termination. Always try to get at least, but have something in your policy that says how often they can enter a payback agreement and how often they can breach it. 2 times in their lifetime, 2 times in a year, 2 times in a 3-year period, whatever, and follow it, okay? Failure to make that required monthly payment or breach of a subsequent payback agreement and or termination of the residence lease or home ownership agreement can result in a permanent loss of eligibility for future services or benefits offered by your tribal housing program. If your resident does not comply with the notice of delinquency or the resident otherwise breaches the lease, the resident can be served with a written notice of termination by certified mail, return receipt requested, or you can have it police served. We did that, or we had the court service them. The notice states the reason for the termination. The resident may respond to the notice or may cure the violation or bring the delinquent amount current. So the resident has the right to request a hearing in accordance with your grievance procedure if there's a discrepancy with any of the notices. Otherwise, the recipient may begin your administrative hearing process. At the hearing, if the resident is delinquent and not violated any of the other provisions, you can negotiate a payback agreement with that home buyer or renter, in which the resident will be required to pay an additional amount on top of their required monthly payment. This is something you guys need to know. When you sign a repayment agreement with somebody, and you know how you have to always calculate to make sure that you're not charging them over 30% of their adjusted income, a payback agreement does not count in that. So if they owe you money, past monies for a payback agreement, you don't put that in that calculation, okay? So if they default on the payback agreement, the recipient may commence eviction proceedings. So your collection tips: establish the ability and willingness to evict. If you don't evict people, they'll end up not paying their money. They'll say, they don't evict anybody here. We don't have to pay our rent. You have to be willing to do that. And once you evict, and it's known that you evict, everybody comes into line normally. Match your policy with your practices, follow up, use receipts, remember to say thank you, recognize the participant of the month, emphasize positive payment history, aggressively offer job placement services, promote self-sufficiency, anything you can do to make it easier for them. Address your toughest cases in your staff meetings. Revisit incentives for prompt payment. Communicate with both spouses and other family members if appropriate. Develop skills in using your appropriate court system. So this is a collection process. All instances where there appears to be a failure to perform, legal action should be preceded by taking the following actions. Call them by the phone. Make a home visit. Write the first letter to explain, this is the efforts to contact the family. This is the nature of the issue. This is the process to resolve it. This is the time frame that the housing staff has to be notified. Then there's a second letter, same thing. Efforts to contact them, nature of the issue, process to resolve, time frame which the staff have to be notified. The third letter informs them that it is being referred for legal action. Documentation is critical if you're going to evict anybody or bring them to court. Okay, you have to have that. When dealing with maintenance, research, collection, documentation is critical if legal action is pursued. Letters describing noncompliance, the corresponding corrective action details has to be supported with written documentation. Phone contact prior to submitting a corrective action plan should also be documented, but it's necessary. It's an opportunity to prepare that family prior to start receiving those notices. You've talked to them and said, hey, we're calling you regarding this past balance, and we're going to be starting this procedure. Basically 3 strikes and it's got to be fixed. So eviction provides the remedy of last resort. Your tribe or housing authority may file civil action against a resident in appropriate legal jurisdiction premised on the breach of agreement arising from non-payment or other just cause. Last question. When should you evict a participant for non-payment? Within 30 days of their missed payment? Never. They're your tribal member, or as a last resort. Yay, you guys listened. Of course you did, didn't you? Okay, that's all, folks. There's my thank you for everything you guys do. If you have any questions, put them there. Thanks for your commitment and services to providing housing for your community. There's my information if you guys ever need anything. And our lady Brianna probably has that last survey for you. I am so sorry that you are 20 minutes late.
Thank you, Cheryl. Thank you so much for all of the wonderful information. Thank you, everyone who participated. I'm just going to go ahead and add the link for the webinar feedback survey there in our public notes. And just as we close out this webinar, please go ahead and submit any final questions that you may have for Cheryl. Of course, all of Cheryl's information is here. She doesn't mind if you send her an email or anything like that if you guys had any questions. Also, take a moment to complete our survey about today's webinar that I dropped in the public chat. It only takes about a minute or so, and your feedback really helps us to do more of what is working well, and just kind of help us on improving our topics and improving our webinars. We do invite you to be as candid as you like, because the survey is completely anonymous. So please make sure that you do complete the survey for today. And we also hope that you can join us for our next webinar. We also encourage you to sign up for our email list so that you can always be aware of the exciting webinars and trainings hosted by the NLC. Our next big webinar is going to be how to tell your smart story and grant applications. And that's going to be with Diane Leonard, and that will be on September 18th, 2025. So we hope to see you there. And also, feel free to access this particular webinar and any other recorded webinars that we have at our Cathedra Webinars archive, now posted to our YouTube channel. Feel free to view them, and you can also share them with your colleagues and your friends. And also, please check out our upcoming events posted to our various social media. You can find us on Facebook, Instagram, Twitter, and LinkedIn. We also have an in-house podcast titled the Hopathanga Native American Podcast, where we discuss more focused topics within Native American housing and self-determination. You can also listen to us on Simplecast, Google Podcasts, Spotify, Apple Podcasts, as well as view the video recordings with our guests on YouTube. Once again, everyone, thank you so much for joining and participating today. We hope that you have a fantastic rest of your day, and we hope to connect with you very, very soon. I am going to leave this up for a couple more minutes just so that you all can grab the links and grab the survey information and any of the slides information. Cheryl, thank you so much. I hope that you have a great weekend. Hopefully you get some rest. You did an amazing series this week, so thank you so much.
No worries. Thank you, my girl. Stay safe.
You
all
too.
Of you guys. If you ever need anything, let me know. Happy Friday. You're right. Woohoo! We made it.
Happy Friday.